Item number 3, my lord.
Yes,
Wanted to
Recording in progress.
So Jayakrishna Mahapatra for the petitioner. Item 3.
Item number 5,
Just
Your
one
Lordship.
second. I have to dictate because I'm adopting a little bit different. ଆପଣ ଯିବେ ହେରି ନା ରହିବେ ଅଛନ୍ତି କୁଆଡେ ଯିବେ?
39 item.
Jayakrishna Mahapatra for the petitioner. Okay, I'll pass that order. I'll record what is the challenge. Then you are seeking withdrawal. Then disposed of order to be communicated. এটা দেবে তাহলে Yes, madam.
Item number 5, Your Lordship. Praying for adjournment.
Miss Pragya Alina Das for the petitioner. After hearing of the matter at length on 19/1/2026, on 19, it is being adjourned. It has been adjourned. It has been adjourned on 19/3/2026, 6/4/26. Today, what is the reason? How can I pass a judicial order after 3 months? You must understand, this is a judicial process. Left to myself, I'll be happy to adjourn. I have no difficulty. Because cases are many. But I have to pass a judicial order. Then what is the reason for keeping the matter pending after 3 months?
One last chance, Your Lordship.
No,
My
the
senior-
fast adjournment was a last chance. Have you marked the English language? There is nothing last, laster, lastest. Why? Last is always a last. Like true facts. Which fact is untrue?
Your Lordship,
Sometimes we use wrong language. The chance was a last chance for the first time. And what would happen after, on a senior judges asked me that what would happen after the last chance? I had no answer. I don't know anyone has an answer. Honestly. Again, the matter is sought to be adjourned, being mentioned by the learned counsel of the petitioner, stating that the petitioner is seeking last chance. Apparently, there is no reason to adjourn the matter after it has been heard substantially. However, to grant further opportunity, the matter shall be listed. ଛୁଟି ପୂର୍ବରୁ ରଖନ୍ତୁ ଫ୍ରେଶ ଆଡମିସନ ଆପଣ ଯୋଉ ଆପଣଙ୍କର ଆରମ୍ଭ ହେଇଗଲା ଆପଣଙ୍କର under the same heading for fresh admission କରିଦେବେ same ନହେଲେ କି fresh admission.
Page 2, 6 to 16.
Item 16 permitted me to withdraw.
Achha. Kindly give your memo, I'll pass that order. Notice is insufficient also.
Yes.
Okay.
She does not want to proceed.
Notice is
Also,
insufficient.
the letter also. Annex.
Yes, you saw that you'll get a letter.
Yes.
So please annex that letter.
Yes, yes.
Originally written.
By WhatsApp matter recently.
Okay, you written that WhatsApp also print. Attested କରି ଦେଇ ଦିଅନ୍ତୁ ଠିକ ଅଛି 19 ରେ ରଖନ୍ତୁ 16 ରେ withdraw ଟଙ୍କା ହବ ଠିକ ଅଛି. Page 3 item 17 to 25.
Item 8, Millard, pardon.
8.
Yes, no.
Last two I'm already have crossed that 8.
Millard.
Path should always have a aim. Actually. That is the specialty of path.
Senior was arguing.
Even in English, this path still you have to aim perfectly. You missed your aim in 8. Now we are at 17. 17 to 25.
Item number 24, madam.
Yes, please.
On the last occasion, 18th of March 2026, the Hon'Ble Court has directed the state to file a counter, madam. It's a matter of 2021.
Basically, there will be truncated because of tomorrow's events. So there will be less time today.
No, I only
assignment. So no, I mean you did not adjourn. It will be adjusted. If you want any specific date, this matters
because it cannot be heard without this state.
No, obviously, in fact, I am not opening any hearing today purposefully, because opening and then just keeping it adjourning it becomes difficult. opening with a objective to conclude. So you do not have a counter. Eta kahara 24 re Mr. Lekha.
The last occasion, Prabhu Prasna Bera
Prabhu.
was there, and he
Prabhu should take care of everything.
and he
Remind
undertook
Prabhu.
that the counter will be filed. But the order was
Date specific date आपण ଚାହୁଁଛନ୍ତି କି?
vacation पर ଗୋଟେ ଆସିଲା।
Author କରିଦିଅନ୍ତୁ।
ତା ଭିତରେ counter file କରି ଦେଇତେ ପଡିବ।
ଏଟା ହଉଛି after notice sir.
Yes.
ଆପଣ ଯେତେବେଳେ ଆପଣ ଆଗ ରଖିବେ fresh orders. After notice ରେ ଟିକେ ଦୂରକୁ ରଖିବେ। ଆପଣ ଯଦି ଭର୍ତ୍ତି କରି after notice ଫେରେ 300 ଯେମିତି ହେଇଛି ହବ। 4 5 it has become 101 11 5 100 18 5 60. This is the situation now. 260 already for the next working days it has to be adjusted. Judicially specifically
Any
added.
date after?
No, he's that I am telling him.
6-7
We commencing 6-7 करते then order होगा see करेंगे computer
Interim order will
entry order touch हो आगे ଥିବ ଦେଖିବା next page item 26 to 33
Item 31.
yes sir
Today I am filing the reply affidavit. The counter, there was a direction 1/12/2025.
other side ଅଛନ୍ତି କି এটা TRP
I have taken consent. He has also some difficulty.
after vacation
After vacation.
TRP ଟା after vacation ରଖନ୍ତୁ
We commencing 13
Huh? କେତେ?
13-7
ନାଇଁ ଶୁଣନ୍ତୁ ଆପଣ ଏଗେନ୍ ସେଇ ଆପଣ ସେଇଟାକୁ ରଖିବା କଥା 13-7 ଏଟା ବି 6-7 ରଖନ୍ତୁ ସେଇଟା 6-7 ହେଲା ଆପଣ 13-7 ଚାହୁଁଛନ୍ତି ମିଷ୍ଟର ଜେନା
ନା sir.
13-7 will be the third week after the opening week
I have no problem.
13-7 करते
Yes sir. ठीक.
any matter
Page 5
Item
May-
39. Can we take the factor value, sir?
39
May I mention,
ଏଟା ବି
may I
TRPC
men-
ଦେଖି ରଖିବେ ହେଲା TRPC ମାନେ ଗୋଟେ interim prayer ଅଛି
6-7
proceeding pending ଅଛି
Item 36.
yes please
If it is reaching, I have no objection, I cannot be.
sir it will not reach
So I pray stay.
because of the
Stay of the
Resting,
execution case. I filed a petition to which there has been no counter.
stay of
Stay of the execution proceeding.
execution sir
Execution, they have already initiated the execution case, which is 92/2025.
after initiation of the proceeding
After
the it has been filed
after completion of the proceeding,
ଆପଣ you are for the other side
already filed by counter, the application. But I have not received the copy of the interim application.
interim
You did not-
stay of execution.
Well,
Which they have
is it your argument that for interim application to be technically yes but passing an interim order should it be served on you
No, not at that point of time, but.
then
recently
what you have filed is a boomerang
Recently,
No.
the filed this interim application.
without understanding also no
So,
have you followed the questions what is the boomerang
I said that they should serve a copy of,
correct how is it a boomerang
because of the fact that order, at the time of passing of that order for stay, serving a copy, no.
not understood sir
That's.
not understood sir you are not getting the point also sir when you have filed the execution case
Yes.
did you serve a copy here
No, I have filed prior to the filing of the writ application. Notice was served after that.
so are you after service of notice
Yes.
if you are proceeding there have you filed a memo to them that I am proceeding in execution
I am not filed.
then
Because
is it not a pending writ petition
it is a legal.
so why you are proceeding there
The landed executing court is proceeding on the fact that since there is no.
did you make a prayer
I have not made.
then so you must understand calculate if you take that plea that you have not intimated the other side it is you who has not intimated the other side and it is pending before this court so don't take pleas which will backfire at you କାରଣ ଆପଣଙ୍କର ଯଦି ସେ ଆପଣ ସହ କଲେନି if you do not inform and the lauded trial court proceeds you plead ignorance of the proceeding then
No, I have not.
that's the problem then you have to say I'm not aware what is that
No,
that will be risky proposition again. So it is your execution case.
Yes.
You are the opposite party here. You are saying the trial court is proceeding there. Understand? If the trial court is proceeding, it is your duty to tell the court because it is your proceeding.
No, they have already informed this factor. This is report.
Not they, sir. You. It is your application. What do you mean by they? In your petition, who are they?
Present person.
No. So then you have to inform it to the court that we are party to a proceeding, and if you are agreeing for adjournment, then it's no problem. I don't know what happened exactly because you may not be having that
The
idea.
last two occasions, the case has been adjourned. The execution case is posted to 10th of January. So now I only have a single objection that stay may be granted. But
No stay, sir. You cannot dictate the court to pass any order or object or appreciate. You have to accept it. Don't get overboard. Even if you object, this court can pass order. So please appreciate. But if you say that copy has not been served, you are a party here. And the last date is definitely after 2025. When I asked Mr. Sinha, it is a pending proceeding, I looked at the case very quickly, I realized what I am asking. Because to be particular is a good habit. I am not finding any fault. But let us be very particular. This is the hallmark of your profession, my profession. Item 36. Mr. Mohito Sinha for the petitioner. Senior counsel. Mr. Sinha, designated senior, not yet. Mohito Sinha. Petitioner, your name, sir?
Mr.
Mr. Abhishek Pal for the opposite party. 2 and 3. You are there, sir? No, please take your seat. आइए आपण आइए फाइल करछन्ती एबे
आगे
आइए कॉपी सर्व कर दियो
आगे 1517541
हैं
2728
728
Sir, two interim applications.
स्टे कोटा रे फाइल अछि स्टे कोटा
JH 17541
एकान देखा जाऊ और फिजिकल कॉपी काढ You have told me thrice. So why I am looking for it? What is the reason? Think further, sir. Don't get stuck. You can guess it that the court is not getting it. Instead of saying that the court doesn't find it, you must think that why, even if you are telling it so clearly 2-3 times, why it is being asked by the court. Two 728 होची ता पूर्वरु जजमेंट स्टे ପାଇଁ कोटा रहितला
17541
पड़ी गला मिल गला The matter being in the list under the heading for admission within courts is mentioned by the learned counsel for the petitioner. The matter being in the list for hearing under the heading. Is mentioned by the learned counsel for the petitioner. He submits that 2 interim applications have been filed. IA 17541 of 2025. और ऊपर heading पे जो share कर देते ना. IA 17541 of 2025. IA 2728 of 2026 and WPC number 28922 of 2025. तापर कौन लिखले? He mentions he has filed the petitioner has filed 2 interim applications seeking interim prayer therein and the matter be taken up. The learned counsel, Mr. A. Pal, is present on behalf of the opposite party. He is served with the copies of the interim applications in the court today. Both has been served. So, in the writ petition, notices were issued by the coordinate bench. The order dated 14/10/2025. Pursuant to the said notice, the opposite parties 2 and 3 have appeared. Appearance state भी party. One Mr. Lenka. The PN Lenka is one. 2, 3 Mr. One. Is submitted by the learned counsel for the petitioner that the learned executing court is proceeding in 92 in execution case number 92/2025 arising out of PLA case number 17/20/2021 into bracket PUS bracket close to Bhubaneswar. Stop. It is submitted by the learned counsel for the opposite party. Are you sure? I'll record your submission that it was filed prior to filing of writ petitions. The execution was filed prior to filing of the writ application, the present writ application. Filing date कहीं देखा जाओगे? तो slip टा कहीं? Scanning. What is it? तेरह दस 25 Mr. Sinha.
They filed in
Younger Mr.
June,
Sinha 13/10/25.
in June,
So June,
whereas my writ was filed in September.
October.
My writ was filed in 25 2025. After my filing, they filed in 26. Their date, filing date is
This no purchase. Upon filing के बेकले confined to that. Don't go.
June 26. sir.
नहीं June
June
26 रे notice issue है
25.
sir. नहीं number टा तो 25 ना. अरे अपन filing date टा कहले होता नहीं notice issue है चिबली भी कहउछन. कौन देखिले? 13/10/25 रे. काई भूल कहउछन गोटे कहने भूल record कर दे.
notice on issue by the school.
केबे अपन आगे file करछन that is your submission sir. You should not have without checking the facts. You are too loose then. Read केबे file हैला no. अरे कोटा मजे मजे अपन जो नो कहउछन बड़ा आश्चर्य लागुची. कोटा नो कहउछन. मु कोटा कहले अपन सेटा नाही करछन. अरे नाही आगा in the month of October. Read केबे file हैला जानिचंती? आपण केबे फाइल कल एग्जीक्यूशन काई कहउछन ताले जे आगुआ फाइल करथिली बोली. My question whether notices were issued you appeared appearance date अछि. तेतरे कोन बड़ कथा रे. आपण क्वेश्चन टा को let us not change. You आपण ओटा भलो आंसर देबे कोन क्वेश्चन चेंज कर देबे. Then why you have said it? I have to say now write that you are withdrawing your statement or I say that you are stating that it was filed before.
Since notice was not issued.
अरे अगर no millets notice तो 10 तरह कहले माने what turns on that? हैं?
Writ application पूर्व file
Again, you are a lawyer, you are not an agent. Unfortunately, what is the difference between a lawyer and a person that कहले से पठौची लोको पटेगा मु समान कर देबी सब ठीक कर देबी. You are at a much higher level. आपन इंस्ट्रक्शन ठीक रे जहा कहला कथा कहबे. That you defend, not difficult. आपण appearance पूर्वरु फाइल करछन्ती सर जानियाटा भी कष्ट न. But the question was not that. And trusting with your enthusiasm, I dictated the order without verifying. Usually I verify, but I trusted you. Only.
That's what I filed for the
Execution. Execution application was. Thanks for the correction.
23 ମୁଁ ଫାଇଲ କଲି 29/9.
Thankfully, Mr. Sinha has realized it. So he is the now assistant.
The difficulty is that I had filed the one application in the month of June, since the some defects were pointed out. And again filed another application in month of October.
সেটাকে উইথড্র করছেন?
Nice, sir, say withdraw on say same way, जो defect
এইটা কেমনে হবে নম্বর হবে?
nice, sir, say defect जो point out ହେଇଥିଲା, defect ସବୁ remove କରି that defect ଥିଲା point out.
নম্বর পଚାରୁଛି স্যার।
In the same.
ଆପଣ ଡିଫେକ୍ଟିଭ ଫାଇଲ କରିଦେଇଥିଲେ, ନମ୍ବରିଂ ସେଠି ହେଲା ନା ହେଲା?
Numbering defect ହେଇଥିଲା, office not defect point out ହେଇଥିଲା. Same way notice should not be issued. That is the reason in the year 2026 notice of issue.
ଆର ଅର୍ଡର ସିଟ୍ ନ ଦେଖିଲେ ଜଣା ପଡିବନି। ଆପଣ ଯୋଉଟା ପ୍ରହଳିକା କହିଲେଣି। उन्नीस एक 26 नोटिस इश्यू ହେଇଛି। और लिख was filed on date time execution application was filed on 28/6/2025. Prior to filing of this application, stop now on Daisy no 2025. Stop. It is further submitted by the learned counsel for the opposite party that the state execution application was defective. The defects were removed in October 20 date October sure though. Sir, this is precisely your job. You are officer of the court. Upon jaha kahibe reproduction. Because it's not a question of trust or otherwise. It is your responsibility. In October 2025. ठीक है Forget it. But October sure though. October 2025. You look at Mr. Sinha. He has a copy and why he is saying that it is in his favor to say that writ application was filed earlier. Technically, writ application is earlier. But he has found out the copy, sees that the notice is prior to writ petition. That is how you get the clarity. Moved in notice and notices have been issued in data on 3 notice data देखिए आपण petition टा दियंता उतरला
Sir,
तारकर ऊपर देखिए गोटे जो नोटिस देउची गोटे डेट पड़िछो 18 बोधे 18 के
26/2/26 रे पाइ
ऐसे सेटा 22 रे पाइना ऊपर अछि आपण स्टाफ यस नोटिस डेट केते
19 के 26
थोड़ा
नहीं सर थोड़ा
21/26
तळे डेट 19 पड़िछो रजिस्टर इशूड ऑन 19 के 2026 शॉर्ट ऑन ऊपर ताकर एम रे गोटे स्टाफ भराइ करते असिस्टेंट मैनेजर
रिजर्व मैनेजर
डेटा नो सर ता पूर्व नोटिस ऊपर पूरा डालिया फर्स्ट पेज पे मत कर दीजिए
रिजर्व मैनेजर
उन्नीस के 26 आपण 20 के काई करछथि
नहीं सर नो नहीं
आपण वेस्ट करछ we are fixing the date of appearance to be 26/2/26 stop. It is submitted by Mr. Sinha, learned counsel, that after receipt of notice of execution they have again filed the application 2728 of 2026 for stay of the execution proceeding, though the earlier IA 17,541 of 2025 held on 23/9/2025 is still pending. It is submitted by the learned counsel for the opposite party, Mr. Pal, that the next date of posting of the execution case is on 10/7/2026. Accordingly, in the interim, it is directed the execution case shall be posted to a date beyond. ଆପଣ କେବେକୁ ଲୋକ ରଖୁଛନ୍ତି ଅର୍ଡର ଗୁଡାକ 6-7
ଆଜ୍ଞା
6 ନା କେବେ ଡେଟ୍ ଫାଇନାଲ କୁହନ୍ତୁ
6-7
ନା 13-7
13-7
ମିଷ୍ଟର ସିନ୍ହା କୋଉ ଦିନ ଆପଣ ଡିସାଇଡ୍ କରନ୍ତୁ ମିଷ୍ଟର ପାଲ୍
ଛୁଟି ପରେ ଏନି
ଛୁଟି ପରେ ଠିକ ଅଛି shall be posted beyond 27 as would be convenient to the learned court in season of the matter upon a prayer being made for the said purpose. You have to make a prayer there.
Yeah.
The matter shall be listed for orders. Now the after notice ଆପଣଙ୍କର order से ଲାଭ ହବନି କିଛି କରି.
I already had the counter.
You also may say
If biddings be completed.
memo.
Okay. The matter shall be listed for admission in the week commencing 13-7. The parties shall complete and exchange the pleadings if not already done. That's the next step.
Already
I'm not granting stay in any matter. Usually I'm
it is in the month of July.
Yes.
So prior to that, it
Yes.
can be disposed of.
hope sir it is a 25 matter.
May
ଆପଣ 25 ଆଗରୁ ଆପଣଙ୍କର ଅନ୍ୟ ପୁରୁଣା ମ୍ୟାଟର ଗୁଡାକ ଅଛି ନା
ଏଟାରେ 2 ମିନିଟ୍ ଲାଗିବ ଖାଲି ଗୋଟେ your worship is so well versed 2 ମିନିଟ୍ ଲାଗିବ ଅବିକା ବି ଶେଷ ହେଇଯିବ
ବର୍ତ୍ତମାନ ତ ସାର୍ ବୁଝିପାରୁନଥିଲି ଡେଟ୍ ବାହାର କରିବାରେ ଲାଗିଲା 15 ମିନିଟ୍ sir that is the beauty of our I mean profession.
may refer the certificate of today's order.
Yes ଆପଣଙ୍କର ଇଏ କପି ହେଲେ ହବ ଅପଲୋଡେଡ୍ କପି
ମାସୁ ଭାଇ
the parties to act upon copy of the today's order obtained from the official website of this court. Urgent certified copy as follows.
Please, your lordships, if I
Mr.
may,
Pal, please don't take anything personally because you have to work. This is the best part of your life. No, not a mistake. You should have checked the dates.
Yes.
Because how Mr. Sinha has found it out. He says that it is filed in June. So then you said that though in June, but it was defective. So defective filing is no filing. That is correct.
if I may, your lordships, if I may mention 40, item 40, your
Item
lordship.
7 what he mentioned. The part
Item 37.
37.
I'm
Much.
appealing for the opposite parties.
That is-
I'll have to file a counter. Professor may kindly adjourn, sir.
But not possible it will be because today that is very.
I have already informed Mr. Amit Bose also. Yesterday,
date kariye sir.
yesterday evening,
that matter is there.
Yeah, see is there.
It will continue.
it will come in after the vacation.
Vacation रे third week होची आपणकर 6 fourth week होची माने अब third week होची 13 second week after the opening to 6 13 7
Not Terasa, but Terasa Sadi Kisho.
27 27 yes sir.
Oblast.
Interim order to be continued.
नहीं इंट्री मॉडल टच हबन कंप्यूटर रे जोडा पोस्टिंग होची सेटा करिवे नो टच ऑफ बट इफ देयर इज adjournment order like this what I passed then you have to mention it because it has to be adjourned again to another date होचे ना इंट्री adjournment stay ताले stay remains on task Mr. Pro.
May I
Yes madam 40
40, item 40, your lordships, we've received the counter by OP number 2 and 3. I seek time to file rejoinder to the same. We've already spoken to the opposite side, Mr. Shetty.
yes Miss Pandey since it is not likely to reach you take a date
Much obliged.
date karantu
we comes in 13-7
we commencing 13th of July
Much obliged. Much obliged, your lordships.
and only it will be posted in the computer no order to be passed that's
Much obliged.
helps in saving time
Much obliged. Much obliged.
yes
item 1
part kore gala yes part
Item 8,
8
we're praying for an adjournment.
Mr. Partha Agarwal on behalf of Ramdas Achari for the petitioner
Power is there.
yes so Partha Agarwal for the petitioner 8 re Partha Agarwal for the petitioner Matter was adjourned earlier on 30/3/2026. Start. Adjournment today today the matter being in the list is mentioned by the learned counsel for the petitioner seeking adjournment in absence of the learned arguing counsel. Stop. After vacation and before.
After vacation.
Accordingly, the matter shall be listed for fresh admission in the week commencing
6/7.
6/7/2026.
Gratefully.
Item 1,
In item 1, I am for the opposite party in item number 1, and sub item 1, I am for the petitioner.
Yes. So this was learned senior suggested that they should be listed together. But where is the other side, sir?
My learned senior also is an accommodation.
After vacation.
No, my lord, 1 week after.
Vacation पूर्व week कौन
Yes, my.
I
1 week after, my lord, next month or first week.
Next month first week rate of it has crossed 100. 11th week it has crossed 100. 18 week रे रहो. There's some 58 टा अछि so ଟିକେ better chance.
Yes.
Petitioner ଆପଣ କହୁଛନ୍ତି petitioner counsel accommodation ନା ଆପଣ senior accommodation?
No, my lord, in sub item 1, I am for the petitioner.
Correct. प्रथम matter you are the opposite party.
Opposite party.
So has the petitioner informed you anything? That I am asking you.
No, my lord.
Is going on.
No.
One रे लिखिए petitioner नाम. Your name, sir?
Satyajit Paltasi.
So you are the Mr. S. Palta Singh. Name पे लिखिए Mr. Samit Kumar, Mr. Senior Advocate, along with Mr. S. Palta Singh for the opposite party. Second matter टा अलगा कर दिए. The learned counsel for the petitioner or non-appears for the petitioner when the matter is called. The learned counsel for the opposite party seeks accommodation in absence of the learned arguing counsel. The matter shall be listed under the same heading in the week commencing 18/5/2026. Second matter. Mr. Satyajit Palta Singh for the petitioner, opposite party blank. The matter is listed together with WPC 18941 of 2019. In view of the order passed in the said matter, the matter shall be listed along with the said writ petition in the week commencing 18/5/2026.
And there is a liberty granted to the petitioner for move an application before the trial court requesting the court not to pronounce the final judgment.
ସେଟା କ'ଣ order ଥିଲା କିଛି?
Yes, ma'am.
କୋଉ order ଥିଲା କହିଲେ?
Already in order number 1. WBC 6203 and IA number 3505.
नहीं 18941 ରେ କ'ଣ order ହେଇଛି? 18941
No.
ଆପଣ 18941 ଟା
No,
lead
my lord,
case.
there is no. I am for the opposite party, my lord, in 1890. 18941.
ଆପଣଙ୍କର stay ଦରକାର ଯଦି ଆପଣ 25 matter ତେ ପର୍ଯ୍ୟନ୍ତ stay
Direction ଦେଇଥିଲେ କି stay grant କରିବେନି କାହିଁକି ନା earlier there is an writ petition filed for the early disposal.
ହଁ
But I am challenging in
ଆପଣ order number 1 ଟା କହୁଛନ୍ତି 6203
6203.
then order number 6203 ଯୋଉଟା next second matter ରେ ତାମାନେ order ଲେଖିଛନ୍ତି ହେଲା first matter say the learned counsel for the petitioner refers to the order dated 11/4/2025 passed by the coordinate bench. He particularly refers to paragraph 6 of the said order. Stop, no comma, and 6 extension of the interim direction. Para accordingly it is directed upon a prayer being made before the learned judge, learned court in session of CP number 288 of 2017. कौन लिखता है sentence টা? कौन? The Lorette court shall not pronounce the judgment till কোথায় গেল? 18 রয়েছে। তাহলে এটা 11 রকে দিন। 11 রকে দিন্তু we commencing 11/5 shall not pronounce the judgment till 21/5 এটা সেকেন্ড আইটেম রে করিও yes
Item 2,
so Mr. Bhuya for the petitioner, Mr. G.N. Lenka for the state, AGA for the state. Yes, Mr. Bhuya.
My lord, the petitioner working as a full-time teacher in a non-government aided college. She was eligible
ଆପଣ UGC scale ଚାହୁଁଛନ୍ତି?
to get the UGC scale. That
You have mentioned a date from 1/6/1989, sir.
I got
No, kindly, sir, listen to the question, sir. It has a purpose. Because, sir, we have to cut short. Otherwise, only for free orders matters, we have already consumed 45 minutes. Sir, are you getting it or you are not at all getting UGC scale?
I was getting in the state scale as per the 1990. But actually,
What you are getting is not the answer question.
the
Sir.
thing is,
Sir, question is very specific and pointed.
man,
Till now, you are getting UGC scale?
No.
No. Answer, sir.
Sir,
So now, so kindly appreciate this.
my lord, similar grievance has been considered by the coordinate bench into that is.
As the coordinate bed says that there should be no further adjudication in any matter. When the coordinate bench will pronounce like Supreme Court, there will be no future adjudication, then I will not hear. Because it becomes easier for me. But if the coordinate bench has considered a case because in service law, res judicata is a very difficult proposition because it is judgment in persona. It is not in rem. That's the first principle, basic principle. So if I want to apply even that law, that stage has to come. They have to consider. Now, Mr. Lenka may stand up and say that it is covered. So I have no problem.
This order is simply to consider director to consider that order.
Consideration, then, sir, I will record that you are submitting your matter to be considered. I am passing. But otherwise, I will not pass the order because it is the petitioner. Kindly read the prayer. Read your prayer. What you have made. Do you use this paperless? You should use. It's easy. Page 8, is therefore
Most ably pray that this honorable court may graciously please to admit the writ application. Issue ruling is calling upon the opposite party show cause as to why the petitioner shall not be entitled to receive UGC scale of pay in the spirit of the resolution dated, that is 6/10/1889, since dated 1/6/1989. Actually,
secondly read further. You have not completely read the prayers.
And or as to why the petitioner shall be entitled to receive the arrear amount consequent of the UGC scale of pay from the due date, that is the 1st June 1989.
So now you are changing your prayer. You want that you will not press this prayer and you want to approach the authority for consideration of your grievance. So if I well pass that one.
My lord, and that order has been passed to consider only the coordinate bench, and that order was challenging the.
Sir, did I say that I do not believe you?
My lord,
Please
that
appreciate,
order
sir.
was challenging the Supreme
Sir,
Court.
by saying so many things, we are just wasting our time. If you want that, you file a memo that you are not pressing the prayer.
Fine.
I'll pass that.
Fine.
Please. Yes, Mr. Lekha, please. Because your prayer is not that. Your prayer is substantive. And my understanding of law is that if a prayer is made before me, then I have to adjudicate.
Right.
The authority himself or herself is not competent also to do my job. In that sense, he is competent to grant it. Better, in fact, more competent than me to grant it and consider. But adjudicatory process, it has to be here.
Annexure 6 is pending.
Yeah, but prayer ta change kar dele na. Prayer ta substantive se मांगुଥିଲେ. And I think your approach is correct, Mr. Bhuya, because unless they take a decision,
Yes.
as a lawyer or to, challenge it, Mr. Lenka to defend it, and for a judge to adjudicate is very difficult. It's always better that there should be some outlines of a determination so that you challenge it. And he will like to definitely defend it because he's the task to defend. And I will adjudicate. कागज दे ले सर, फिर मेमो दे दीजिए. The petitioner is stated to be working as a reader in Odia in K.M. Women's College. This is not a category 1 college, I think. Category 2. Category 2 टा को provision रहा
That was in 1994 GI order.
The petitioner
Women's College.
K.M. लिखी थे मैं भूलवाल शायद पढ़ इसी पूरा डिस्क्लोजर. The application has been filed under the Articles 226 and of the Constitution of India, read with the Odisha education into bracket. देखिए 74 with the following prayer, where why the petitioner shall not be entitled to receive up to 1/6/1989. The matter is pending since the matter was presented before this court on 29 June 2020 and is listed for the second time after it was, and it is taken up by this court. Listing and it is taken up by this court for the second time after it was listed on non-of during the COVID period, COVID pandemic period. Stop. The allotted counsel for the petitioner files memo of date which states thus. Para. Memo is taken on record. Can copy be updated? Para. Accordingly, it is directed the petitioner shall move the authorities concerned. Now, making a representation enclosing all earlier representations and all such documents sought to be relied upon by the petitioner, including any pronouncements made by this court or your superior court on the said point. The representations shall be made afresh within a period of 6 weeks, Mr. Bhuya. Within a period of 6 weeks from today. So the representation along with certified copy of this order shall be filed before the authority into bracket IES. The authorities shall do well to consider the same and take a decision within a period of 4 months from date of receipt of the order. The order shall be communicated. Order shall be communicated. Insert the authorities, while taking decision, shall be at liberty to ask the petitioner to provide any other information as may be sought for. And if they are so advised, may grant opportunity of hearing to the petitioner. They will grant. I am not directing. In 6 months for them. And आपको फिर जाए कि दबा पड़े वाले 6 months, 6 months. After the decision is taken by the authority, the same shall be communicated to the petitioner within a period of 2 weeks. Stop. The petitioner shall have the liberty to respond to the said shall communicate it to the petitioner within 2 weeks thereafter, or 2 weeks from the date of decision. Stop. It would go without saying that if the decision is in favor of the petitioner, the authority shall take up the follow-up action within a period of 3 months thereafter. 3 months thereafter, no? 3 months from the date of decision of the authority. Para, the petitioner shall have liberty to seek redressal if agreed by the order of the authority. So, it's clarified that this court has not expressed any opinion regarding merits of the case and the merits and contentions of the petitioner or the parties to the litigation in any manner whatsoever. Original certified copy as per. Yes. पण एटा किंतु पक्की रखिबार नथिला 20 मसिया अवश्य कोविड बेले आसीची यदि से डिटरमिन करिनांती ग्रांट करिनांती कि गोटे डेट रु दैछंती व्हिच वाज माय फर्स्ट क्वेश्चन पण 1/3 2/3 फुल जो भी डेट चेंज हुए यूजीसी रे भी गोटे डेट अछि ऑल दोस थिंग्स कैटेगरी 1 नो कैटेगरी 2 कॉलेज पण एटी जो 6 वर्ष पक्की रखिले एथरे किछि गिल्ट किछि आसीबल एनीवे आई थिंक वी हैव डन द राइट थिंग यस
Item 3.
To withdraw my lord. Both the petitioner and opposite party judicially separated on the strength of a decree of divorce, my lord. And the opposite party also received the permanent alimony.
Right, sir.
Matter is
Mr. Krishna Mahapatra for the petitioner. What on already claim choice and that principle or no? The petitioner husband in the marriage is before this court challenging the judgment dated 13/1/2022 passed by the Honorable Judge Family Court, Nabarangpur, in CRP number 23 of 2019. So, by the said judgment, 13/1/2022 actually, by the said judgment, the petition filed by the wife in the marriage under section 125 of CRPC, claiming monthly maintenance of 10,000 for her and rupees 5,000 for her minor son, was favored. However, directing 4,000 for the wife in the marriage and 2,000 for the minor son from the wedlock, and rupees 2,000 as litigation expenses. Stop. Today the matter being in the list is taken up. Stop. The Lord High Counsel for the petitioner files memo of date which states thus. Stop. Court kale. Memo is taken on. Memo shall be taken on record. Scan copy be updated. In view of the above, the petition starts disposed of. Copy of this order shall be forwarded to the Learned Judge Family Court, Nabarangpur, to be filled in the records of CR.P. number 23 of 019 for reference.
Item 4.
Mr. H.K. Mohanto for the petitioner. Yes, Mr. Mohan. So, S.K. Mohanto for the petitioner. The matter has been adjourned by the petitioner on 6/8 purchasing. Stop. Thereafter, it was heard at length, at some length on 5/2/26. The issues as well as the questions of law were noted, and the learned counsel for the petitioner had adjournment to address on the same. Thereafter, regarding this matter, whether the court should issue notice or not in every matter, that I now have dealt and pronounced. I think I have made it AFI. That is provided in Order 47, Rule 10. PFM also, that principle applies to a certain extent. ଆପଣ ଏଟାକୁ ତ ମାନେ ଆସିଷ୍ଟ କଲେନି ଆଇ ୱାଜ ଏକ୍ସପେକ୍ଟିଂ ଦ୍ୟାଟ୍ ଆସିଷ୍ଟାନ୍ସ ଫ୍ରମ ମତେ ନିଜେ ତାକୁ ୱାର୍କଆଉଟ୍ କରିକି ଆଉ ଗୋଟେ କେସରେ ପଡିଲା 41 47 କହିଦେଲି 41 appeal ହେଉଛି 41 it's a lie. Then another appellate court may in its discretion either before the respondent is called upon to appear and answer or afterwards on the application of the respondent demand from appellate security for the cost of the appeal or the original suit or both. This is what I have discussed. Then 11, power to dismiss appeal without sending notice to the lower court. And the appellate court, after fixing a day of hearing the appellant or his pleader and hearing him accordingly, if he appears that day, may dismiss the appeal. And this was amended. This was amended also in 2002, 99 amendment asila. The appellate court, after sending for the record, if it thinks fit, so to do, after fixing a date for hearing. Sending for records to delete here. This is how the law has evolved. Colleague. Thereafter, the matter was again adjourned. On 5/2 ପରେ 26/2 33 and orders were also passed on 33 2026. Today, the matter being in the list, adjournment is sought for by the learned counsel for the petitioner in absence of the learned arguing counsel. Stop. To grant further opportunity, list after vacation.
We commence 6.
Matter shall be listed for fresh admission in the week commencing 6/7/2026. Yes, please, next.
Item 6.
Yes, please. Mrs. S. Ponda for the petitioner. Mr. Praveen Das for the project party. Yes, Mrs. Ponda.
Today I am filing the affidavit as per order dated 3/2/2026.
3/2. Is submitted by the Learned Counsel for the petitioner that petitioner is paying the amount as directed by the different orders by different courts. Secondly, it is directed to substantiate the statement petitioner shall file affidavit indicating the details of the orders passed, amount directed, and details of the payments made. I want this in tabular form.
Yes.
So it is submitted by the Learned Counsel for the petitioner that in terms of the order dated 3/2/2026, the petitioner is filing affidavit. During course of the day, upon filing of the affidavit, same shall be taken on record. Scanned copy be updated. Copy of the affidavit has been served. Copy of the affidavit shall be served on the Learned Counsel for the opposite party during course of the day.
I'm sorting it out.
Correct. During course of the day is now also.
Actually, my lord, notice was not served to me. I have appeared on my own because the matter is pending since 2025.
Right.
The CP is pending. So I got to know and I have appeared. The notice was not issued. So
Complete it is submitted by Mr. Praveen Das, Learned Counsel, that the matter is pending before this court since First order टा जोटा presented जो लिखा है ना जोटा stamp बड़ा ही presented after being filed on it होला so he submits that several orders have been passed by this court and upon instruction he is appearing for the he along with learned associate counsels are appearing they have filed वकालतनामा तेरा 80 फाइल करो तुम बेटर हो 60 फाइल कर सो दैट संगे मिसिंग जीरो वकालत केबे फाइल कर सो बस फाइल वकालतनामा ओके filed on 31 मार्च 2026 which is on record ता पर एटा लिखि दिसे केबे डेट करियो
But the amount of maintenance till date is around
one
7
thing at least just check what amount is paid what was the order and if with the order which is under challenge according to that what amount would be due
That is 84,000 till date. Okay. The challenge.
so at least now you are aware of the amount of due so you also obtain instruction in these matters never off the cuff contest any figure because you know who is saying you cannot know who is stating what बेले बेले out of context ही जाए insurance so please check up केबे आज छुट्टी पूर्व आसले हबो ना छुट्टी करे
छुट्टी पूर्व मिलो that is my chair.
we commencing 18/5
Oh bless.
Item 7.
Item 7, may I please? Should the present
so Prakash Chandra Das for the petitioner which party blank yes Mr. Das
My lordship, I have my prayer, my lordship, I have filed this transfer petition for seeking for a direction to transfer of civil proceeding filed by the present respondent from Court of Law and Judge, Family Court 2, Bhubaneswar to the Court of Law and Judge, Family Court, Kendrapada.
who ground कौन होगा
My lord, grounds is there, my lordship.
who provision first of all आपण who provision challenge करछन seek करछन let us go to the basics very basic foundational facts and foundational law what is the provision you are seeking transfer
This is section 24 of
24 correct
grounds are there, my lordship.
so 24 does it prescribe any ground
Ground that
does it prescribe any ground
it is
my understanding my reading is that no ground is stated in 24 as such that makes it little bit difficult for adjudication in this sense what ground it should be transferred now what is the jurisdiction which section provides jurisdiction
jurisdiction is section 20, my lordship.
20 of
My lordship, the jurisdiction is there, my section 7 is there.
Section
Family
7 of?
Court. He has filed the CP, my lordship.
section 7 of Family Court Act
She has filed the
correct 13
section 13 clause 1 of the
13
and section 7 of Family Court Act.
correct so which is the provision providing jurisdiction 7 question है पढ़ा कोटा आज
Same that the jurisdiction.
अच्छी आगे कौन निजे पढ़ी ले बे करे 13 टा कोड jurisdiction আছে section 19 Hindu Marriage Act section 19 provides jurisdiction
My lordship.
CPC रे कोटा
CPC my lordship, section
9
9.
so have you examined this before preparing the draft spend some time
My lordship.
so that the problem is there is paucity of time to that's one way of I'm not in a hurry there in that sense but let us not spend time in now after आपण अधघंटे कहला परे मु पचारिबी कोन section 19 रे how it is not satisfying or section 9 or section 7 जोटा आपण सेट करछन jurisdiction so all these have to be treated read together section 7 and 19 have to be read together because it is a 13 application the question is section 13 रे आपनकर 7 application fail होची 7 read with 13 other than Hindu Marriage Act में Family Court Act रे ही परियो suppose customary marriage scheduled tribes again section 7 but 13 is not there आपनकर ground कोन नहीं चल
policy grounds I am stated my lordship in the present petition was coming from the poor family, farmer family my lordship.
କୋଉ ପ୍ରୋଭିଜନ ରେ ଅଛି ସେକ୍ସନ 19 ରେ 24 ରେ ପୁଅର ମାନଙ୍କ ପାଇଁ ପୁଅର ମାନଙ୍କ ପାଇଁ which provision is applicable proforma pauperis
First,
ତାପରେ ଆପଣଙ୍କର ଆପଣ ଯୋଉ ଲଜିକ କହୁଛନ୍ତି I am very impressed actually I am really impressed so look at my order Kendrapada is for the poor family Cuttack is for the rich family
both are from the Kendrapada my lordship.
ନାଇଁ କଟକ ରେ ଯୋଉଟା ଫାଇଲ ଅଛି ଆପଣ both are from କେନ୍ଦ୍ରାପଡ଼ା ମୁଁ କଣ ଏଟା ସୁଟ ଟ୍ରାଏଲ କରୁଛି କି ଆପଣଙ୍କର ଯଦି jurisdiction ନାହିଁ that's a different thing ଆପଣ ଚାହୁଁଛନ୍ତି କଟକରୁ କେନ୍ଦ୍ରାପଡ଼ା because it is poor କୋଉଠି ଚାହୁଁଛନ୍ତି
ମୁଁ ଭୁବନେଶ୍ୱର ମୁଁ ସିଏ ଫାଇଲ କରିଛନ୍ତି ଭୁବନେଶ୍ୱର ମୁଁ ଚାହୁଁଛି କେନ୍ଦ୍ରାପଡ଼ା
ଭୁବନେଶ୍ୱରରୁ କେନ୍ଦ୍ରାପଡ଼ା I will transfer saying that because the defendant is a poor person you see how I have spoiled the entire thing being a supervisory judge I have said that 227 Bhubaneswar is not meant for poor people ଆପଣ proforma pauperis application ଦେବେ legal aid ନେବେ ଯଦି poor court rich court ଥାନ୍ତା କେନ୍ଦ୍ରାପଡ଼ା poor for poor Bhubaneswar is for rich then proforma pauperis is only available at Bhubaneswar you cannot file a proforma pauperis at Kendrapada you cannot take legal aid
several my lordship several grounds are there my lordship.
no grounds there sir that is the life threat how many complaints before the trial court that since you have been threatened
page number
अरे page no sir court रे page कौन हबो आपण जदी कोर्ट को जणेले ट्रायल कोर्ट को 13 एप्लीकेशन रे I have been threatened I cannot appear that's it केतटा एफआईआर दैछन
I have not lost the FIR.
So it has to be rejected. You must understand, coming to High Court and stating that I have been threatened. I cannot direct lodging of FIR. Whether the question is whether you have contemporaneously responded to the live threat. Live threat is to be taken as a ground in that High Court order. High Court, what the High Court will consider? Perception of the individual or the response of the individual in contemporaneous time. That is the difference. That is the difference when a person is coming to you and telling you, "Agya, mate Maria ko dhamkei chanti." Upon asile High Court, that is not your job. See, जन पाखु गला जे कि सेटा समाधान ताको लेवल रे कर देबे बंद कले ऑडियो is to be dismissed. Appeal has to be dismissed. Just now I read order 41 rule 11.
That was my lordship.
We must understand. We must understand that these matrimonial matters are not to be transferred for the asking. The High Court and the Supreme Court has time and again says that it has to be disposed of. And interdiction by this court by directing transfer was just delay. You must understand. And you I record that. That's nothing.
I only my humble submission before me.
Sir, you are not equally very humble. Sir, our humbleness, competing humbleness, does not improve your merit of your case. A humble lawyer and a humble judge do not make a very humble order. The order becomes very nonsensical. If I record what you are saying, poor man by sir, Kendrapada is preferable. I cannot direct it.
Notice should be served.
No, it should not be. It should not be served. Because when I have to record that poor man, Kendrapada is the best place. If you have to say that you appear pro forma pauperis, seek legal aid, do those things. And legality is best available at Bhubaneswar, not at Kendrapada. You must understand that. Complete lack of preparation leads to this. Because if you say at Kendrapada you will be provided legal aid, then why not in Bhubaneswar, which is better? You want to continue with your matrimony or you want divorce? Did you ask your client? This is not a money suit. This is not a property suit or a declaratory relief. What he wants?
My wife, I have. I
Are a call question
I
call.
want
Mr. Das, you are out. Have you asked your client whether he wants to continue the matrimony?
Continue, she matrimony. Ready.
Continue, no. She can't चाहूँचंदी कौन?
She is only want to transfer this case from.
ସରିଗଲା କଥା ସବୁ ସେ ହବନି ମୁଁ ଯୋଉଟା ଭାବୁଥିଲି ସେଟା ହେଇଗଲା 20 ମିନିଟ ଚାଲିଗଲା ଆପଣ କ୍ଲାଏଣ୍ଟ କୁ ପଚାରିଥିଲେ when he has come to you to seeking of transfer at Kendrapada whether he will oppose or support this 31
Easy opposing relationship. Wife
wants to खराब लोक कहउछन्दी आपनको वाइफ धमकउछन्दी you must understand that life threat upon still you want to be closer to your wife who is threatening you and you want to bring her to Kendrapada where you are now threatened. You must understand what you are saying, Mr. Das.
Both are coming from one district, so matter would
Sir, the question would be that both are coming from how many districts? That's not the question. The question is you are so threatened by your wife and still you want her to come to Kendrapada. That is the question. Could you not ask these questions? Unless you ask these questions, it becomes a very ordinary discussion without any legal contents. We are spending time for that. Anyway,
only urgent.
Arjun the ago ଆପଣ ଦେଇଥିଲି ଆପଣ ଆର୍ଜୁମେଣ୍ଟ ଦେଲି ତାପରେ ପଚାରିଲି ଆପଣ କଣ କହିବାର ଅଛି ତ ମୁଁ ଶୁଣିବା ପାଇଁ ଚାହୁଁଥିଲି. So that's it. I am nothing else. I will definitely am adjourning you. ନହେଲେ ଆପଣଙ୍କ ବର୍ତ୍ତମାନ ଆର୍ଜୁମେଣ୍ଟ ଟା ଡିସମିସାଲ କଣ ଚାହୁଁଛନ୍ତି ମୁଁ ବୁଝିପାରୁନି. କହିଲି ପରେ ଆର୍ଜୁନ କରିବି ବୋଲେ ଅବଜେକ୍ଟ କାଇଁ ମତେ କାଇଁ ଅଟକଉଛନ୍ତି କାଇଁ? The learned counsel for the petitioner is heard at length. Section 24,9 of CPC, Section 19 of the Hindu Marriage Act, and Section 7 of the Family Courts Act were discussed during hearing of the matter. The present application has been filed by the petitioner husband in the marriage under Section 24 of the Civil Procedure Code. Seeking transfer of the civil proceeding number 1075 of 2024. Before the learned judge, Family Court /2, Bhubaneswar. To the Court of Learned Judge, Family Court, Kendrapada. Regarding the grounds, those can be argued for transfer as should be provided as have been provided under the not under in the above provisions. The Learned Counsel has adjournment to address. Stop. Seeking transfer, it is submitted by the petitioner that he is a poor person. He feels threat to his life. His father is bedridden. Litigation is costly. Litigation is costly. In response thereto, the Learned Counsel for the petitioner was asked whether, regarding threat perception to the life of the petitioner herein, he has lost any complaint before law enforcement agency, or he has approached the Learned Judge Family Court 2 regarding threat perception to his life, which affects his appearance before the Learned Judge Family Court 2. Upon instruction, answer of the Learned Counsel for the petitioner is no. Stop. Regarding the petitioner being poor, it was the Learned Counsel for the petitioner is also apprised that petitioner being poor cannot be ground to transfer a civil proceeding initiated by the wife under Section 13 of the Hindu Marriage Act. As for Section 19 of the Hindu Marriage Act, that provides jurisdiction and procedure. So, the legal recourse would be the petitioner should seek legal aid and file application for proceeding pro forma pauperis, if that would be relevant and necessary. It cannot be said that it cannot be said no. It cannot be observed by this court that the petitioner's father's residence should be the place of litigation, as Section 9, Section 7, Section 9, Section 24 of CPC, Section 19 of the Hindu Marriage Act, and Section 7 of the Family Courts Act have any such provision that lead to a conclusion, that lead to such conclusion. The Learned Counsel has adjournment. The matter shall be listed in the week commencing. Sir.
After occasion.
Matter shall be listed in the week commencing. Listed for fresh admission in the week commencing 6/7/2024.
Actually, only one prayer. When my IA is there for adjournment, that will be considered.
Just now before, unfortunately for you or fortunately, I have discussed already Order 41 Rule 11. You should not.
DGGS suffering from
DGGS Bhubaneswar is a better place for treatment. It has AIMS. It has 4 medical colleges. It has referral hospitals 5. ଆପଣ ଚିକିତ୍ସା ଯଦି ହେବେ ସେଟା ମେଡିକାଲ ସାର୍ଟିଫିକେଟ ସେଠି ପ୍ରଡ୍ୟୁସ କରିବେ ନା ନନ୍ ଆପିୟରାନ୍ସ ପାଇଁ। ଆଉ ଏଠି କଣ କଲେ ମୁଁ କଣ ଡାଇରେକ୍ସନ ଦେବି? ଚିକିତ୍ସା କରିବା ପାଇଁ ଡାଇରେକ୍ସନ ଦେଇପାରିବେ କି? ଆପଣ ମିକ୍ସ ଅପ୍ କରନ୍ତୁନି। ଆପଣଙ୍କୁ ଯେତେବେଳେ ଗୋଟେ ଲୋକ ଆସିକି ତାର ଦୁର୍ଭରି କାହାଣୀ କହୁଛି, ଡୋଣ୍ଟ ବେଲ୍ଚ ଇଟ୍ ଆଉଟ୍ ବିଫୋର ଦ କୋର୍ଟ। ଆପଣ ତାକୁ ଲିଗାଲି ତାକୁ ଡେଭଲପ କରନ୍ତୁ। ଆପଣ ଲିଗାଲ ଡେଭଲପମେଣ୍ଟ କିଛି ନାହିଁ। ବାପାଙ୍କ ଦେହ ଖରାପ, ବହୁତ ପୁଅର। आपण सेटा kasi exactly सेटा कोर्ट रिप्रोड्यूस कले कोन देखि थांते सेक्शन 7-9 रे जदी हस्बैंड पुअर ताले कोन आपण फाइल करंतु लीगल एड फाइन लीगल एड इज बेटर इन आपण निजे अपियर कर परिबे भुवनेश्वर रे केंद्रापड़ा से फैसिलिटी दे हबो because the bar is bigger here incentive is bigger here why how this I mean legal aid is better in Cuttack and Bhubaneswar not that Kendrapada is can be good also but number of lawyers number of practitioners incentive is much more here adjournment kari hon seti seta apan bujhibe seta I am not you see you must understand you are not assisting your client to get adjournment or not to appear that is the difference between you and an ordinary person you have to tell him in terms of law plain and simple boya ke mo bhubaneswar aga jibini mate jemti le kar jauntu that cannot be a prayer I am not here to pass those orders हम भल लागन भुवनेश्वर जिया से सेठी करइबे that's not rather my job is different I am telling the Bhubaneswar family court dispose of don't keep the matters pending you must understand these are reflecting on our performance and when and every matter is argued on behalf of the wife that wife ro preference dekhundu that also I am not looking at even if the husband choice of litigation section 9 and 13 it has to be honored beyond law ये ऑर्डर पास करियो
से आईए टा खाली मैं
आइए खाली हो कि भर्ती हो करि हो बने आइए has to be dismissed should be rejected you must understand I am not rejecting your IE that is the only thing you can have the be satisfied if you like as you granted adjournment at 12:25 at 12:50 so I never intended to grant you adjournment to take up the IE. Nothing.
That I have filed for stay of posting my let's see.
Whatever. It cannot be state, sir. 13 is not to be state. You must understand that. Matrimonial causes and it is a matter of 2022. 24 मसीहार केस सॉरी 24 मसीहार केस.
Yes, my.
आपण निजे श्योर नोते आपण क्लायंट कोन चाहउछंती. You want to agree to divorce or agree for not to agree for divorce, you do not have instruction at Kendrapada.
Then let's see, keep it in Wednesday. Let's see, I will take instruction from the client.
So that आपण करियो ना आपण किछ instruction नहीं परिबे.
You
have to behave like a lawyer to get instruction. If you behave like a companion and giving solace to the client, he will never give you instruction. We commencing 18-5 कर दियंतु से जो स्ट्रेटजी आपनकर जेंति नोटिस पाइले आसिक टीआरपीसी फाइल कर सेटे एठी काम करू लास्ट 6 मास हला काम करू
भाई नोटिस टा देखले बेले
सेटा आज्ञा नोटिस जीवनी आपण जदि सैटिस्फाई करि परिबेनी ऑर्डर सेक्शन 9 11 24 रे पण बापा को देह खराब निजर माने गरीब सेटा ग्राउंड नाही सेतरे ट्रांसफर करिया ग्राउंड हे परियो and then I have to give reasons sir that Bhubaneswar re legal aid available no must understand that what I am doing I have to be responsible I have to take responsibility as a judge as a court not as a judge apart from being a judge also as a court legal aid is not available at Bhubaneswar poor persons are not there that the matter shall be prosecuted where the father is staying
थाउ मिनिट्स मु इंस्ट्रक्शन जानी
कोन लिबर्टी टू मेंशन करिवे हो तो लिबर्टी टू मेंशन ठीक अछि 8 11 5 डेट 18 5 डेट रहला 4 5 4 5 11 5 200
8 5 रे मिनिट्स अछि डेटा चैप्टर डेटा
मेंशन करिवे
8 5 रे अछि ता पूर्व नै मिनिट्स के हराना
4 5 वीक रे आसु
4 5
हराना के हबल आपन को सेटा कहिबे नै सी कोर्ट रे केस करिवे जो वकील कहबे का लोक हैरान होते आपन को हैरान करी पैसा नोचन फीस काई नोचन तान सेउडा कहबे जो लूज स्टॉक परंतु नै दैट इज contrary to our profession and responsibility also आपण कोन कहि कि केस करू छ यार असुविधा ला आपण को आसिला हैरान कोन होउ छ आपण तो लीगल संदा को देबे ना नै हैरान हम तो बुझिबे बापा कथा बुझिबे बिल्कुल आज्ञा जे जो लोक ये आटीट्यूड बापा से पचार ही नथिबे आपण टेस्ट करो गोटे आपण गोटे टेस्ट केस दोची गोटे गेस वर्क yes
let's see.
we commencing 4-5 ठीक है
Chat first. Okay.
Item 9,
टाइम टाको पोस्टिंग कर दियंतु पिटिशनर ना द मैटर शैल बी लिस्टेड इन द वीक कमेंसिंग 18/5 कर दियंतु ठीक है
item 10,
Make to the lordship and
Yes.
appearing on behalf of my senior MM Patnaik.
लास्ट occasion you were also had madam
Yes, your lordship.
सुमन महापात्र
Yes. See, he taken the adjournment.
अच्छा okay
Lordship, previously the court, the honorable court asked us that.
आद्यासा you are आद्यासा
Yes, yes. Regarding the MSC transfer of from the Burger Tribunal to the Puri Tribunal, we have prayed for that. And the court,
so have you examined the law on this the question is that now the judicial mandate or the law is that it can be initiated at any place
Yes.
you are the owner
yes,
you are the owner of the vehicle
I am the petitioner and the wife.
you are the wife
Yes,
so you are one of the beneficiaries
yes.
so can it be if one of the beneficiaries he or he wants it should be transferred
Your lordship, kindly, I kindly have a glance to 166 clause 2 of the Motor Vehicles Act.
और एटा पिटिशन रे साइड करचंती
No, your lordship.
तल काहे रेफर करचंती now you are doing the reverse आपण 166 रे पिटिशन फाइल करना तो पडुचंती
160
226 पढी होबो काने 226 टा होची पावर ऑफ द हाई कोर्ट
High Court.
whenever you are moving a petition citing 100 ना कोन सेटा किछि साइड करना है 166 कोई काढ दो पढो
As per section 166 clause 2, it written that every application under subsection clause 1 shall be made at the option of the claimant, either to the claims tribunal having jurisdiction over the area in which the accident occurred, or to the claims tribunal within the local limits of whose jurisdiction the claimant resides or carries on business, or with the local limits of whose jurisdiction the defendant resides. The case has initially arisen at the place of Baropalli.
अरे 166 छाडी पळले फेरे क्लेमेंट वर्तमान क्लेमेंट जो आपण जोटा ट्रांसफर चाहउछन क्लेमेंट किए तापरे कहिबे
The
who are
wife,
the claimants
the wife of the deceased person, and the father and the mother of the deceased person.
so who has initiated father and mother कोठी रहउछन
Father, mother, Baropalli, Bargad re rochandi.
फाइल करचंती कोठी
Bargad re ही initially file ହେଇଥିଲା.
then
But
if suppose they have legal heirs staying in US
yes,
it's a concrete example I am giving
yes,
one legal heir staying in Bombay one legal heir staying in US Boston one legal heir is at Bhubaneswar the accident occurred in the place of the residence of the unfortunate victim and which is the case
Where
as
they
per
are-
166
where they-
166 is clearly against you why you are citing that
I am citing this because your lordship.
you file your claim case maybe both cases have to be taken up together you must
Yes.
understand that does it give a preferential choice of one of the legal heirs to file a case at one place no mother father and wife
Wife.
three are claimants the case is initiated at Bargad
Yes.
so if the case is decided at Bargad no difficulty because it will be apportioned
No, because your lordship, after the case, after the husband has passed away, after some months, the in-laws of their wife, they have threatened her, and she is forcefully driven out from her parent in-laws house.
so that is not reflected in 166
No, your
for forceful eviction of one of the claimants from the residential house of the claimants. Can that be a ground for transferring? You must
No,
understand.
but it is.
So don't argue like the earlier matter we spent for more than 40 minutes.
No, your lordship.
So
No,
don't argue like
my
that.
humble prayer is.
I have to reject it.
No, my humble prayer.
I have to record your submission and I have to reject it. The lawyer and the judge being very humble doesn't improve the case
No.
like the earlier matter.
Yes. Your lordship has.
Both are very humble.
Your lordship has previously asked me why the case must
I
be
never asked you kindly because I pass a order.
24.
Look at it, yes. And 166 is completely against you.
So we are ready for to appear in the mode of video conferencing. There is no issue because
So you move that petition. I am not the MSCT tribunal. You are pretending as if I am the MSCT tribunal, you are ready and I am not accepting.
no, you're
Make a petition. If they reject, then you move the High Court. Please understand that.
Sure.
Para 2, you have to read order number 2.
Yes, sir. Learned counsel for the petitioner has urgent
No. Read the order first. Para 1.
By filing of the application, the petitioner seeks transfer of MAC number 100 of 2023, now pending before the First Motor Accident Claim Tribunal, Burger. It is not disputed in the petition that the accident took place on 5/9/2023 at Barapalli NH 26 under Barapalli Police Station. Therefore, the cause of action, all the evidence and witnesses are within the territorial jurisdiction of the tribunal at Burger. Learned counsel for the petitioner has urgent to address as to whether by transferring the matter to Puri, any purpose will be served in the expeditious disposal of the matter. Or
You did not answer that. You started reading 166. 166 is very clear that it is initiated at the proper place. Second argument is that you have been driven out of house by the offer. So I cannot comment.
Your Lordship, my submission.
That cannot be a ground. It is your submission. It is well taken. By repeating a submission 3-4 times,
Yes.
3-4 occasions in the VC and 2-4 occasions here, it doesn't improve. I have some difficulty in forgetting also.
Your Lordship, at the
So
place.
you come out with a proposition either by a citation or a provision where choice of one of the parties has to prevail of the other two parties. That is because you have not answered anything. Though you made out as if you are answering, Lordship directed, Lordship passed order. I have not passed any order. My order is very simple and
Yes.
apparent.
The Honorable Court has asked.
Everything is at Barpali. By transferring it to Barpali, because I did not use the negative language.
Yes.
You want to delay and spoil the proceeding there. Because a tribunal at Puri has to procure the evidence, witness, everything from Burger.
Yes, Your Lordship, but I filed a case. I am unable to present myself in front of the court because there is a severe life threatening. They are not even.
If you are life threatened, this is not the police station.
No, Your Lordship. And
if you are life threatened, you have to bring to the notice of the court, MSCT, by filing an application that I cannot appear when if you are directed to appear, then you have to tell the court, not the High Court.
That is why we have filed the transfer petition because they are.
That is not why. You have not stated. You have been asked.
Yes.
Where you have stated before the trial court that I have been threatened, I cannot appear and trial court has not considered.
There is a DV cases filed in the JMX.
Not DV, madam, MSCT case.
Yes, but.
In MSCT case, where you have stated, by shifting the goal post, you cannot score a goal.
Yes.
Because if I am asking you where you have stated in MSCT, you are saying DV case. Now then your proposition is if a DV case is filed, that is binding on the MSCT court. That is not.
No, Lordship. Initially, I have filed.
Tell the MSCT court. Have you said to MSCT court?
Yes, we have stated in front of them.
Show the petition where you have stated that you have been threatened. And what is the order on that?
But after all that, we have not even. We don't.
Madam, where you have stated before the MSCT court and which is the date and which is the order on that?
I have no instruction till now regarding this
It
because
has to be dismissed. Well, this is the last matter. I'm sorry, I cannot take up further. This will another dictation will take another 15 minutes. Our matter गुड़ाक केतटा रहिला? এটা কেতে নম্বর? আଜ୍ଞା 10 11 12 11 ରୁ 15 ଆପଣ ଆଡଜଷ୍ଟ କରିଦିଅ ଆଜ୍ଞା କେବେ କରିବେ କାଲି କରିବେ କାଲି ତ କୋର୍ଟ ନାହିଁ ବୋଲି ପ୍ରୋବ୍ଲେମ 29 30 1 2 2 ଯାଏ ଅଛି 2 ରେ ବେଶୀ ଗୋଟେ ମ୍ୟାଟର ରଖନ୍ତୁନି ଦରକାର ଆପଣ 29 30 ରଖିଦେଲେ ଠିକ ଅଛି ଅର୍ଡର୍ସ ମ୍ୟାଟର ଆପଣଙ୍କର ଯୋଉଟା ଡିକ୍ଟେସନ ହବ ରହିଲା 16ଟା ଡିକ୍ଟେଟେଡ
20 million.
ଅର୍ଡର୍ସ ଗୋଟିଏ ଖାଲି ମେନସନ ହେଇଛି ନା 16 ଠିକ ଅଛି 17 ରୁ 21 କେବେକୁ ରଖିବେ ରଖିଦିଅନ୍ତୁ ହେଲା 17/2/21 ଆପଣ 29/30/1 ରଖିଦିଅନ୍ତୁ 3 ଦିନରେ ବାଣ୍ଟି ଦିଅନ୍ତୁ ହେଲା। After notice matter ଦରକାର there is some assignment now then thereafter this bench may not be available.
ନାଇଁ ଆମର ତ ଫ୍ରେଶ ଅଛି ନା।
Fresh it will be adjusted by ଆପଣଙ୍କର ଶନିବାର ଯାଏ 4 ଦିନ ଯୋଉ ଅଛି adjust ହେଇଯିବ ଅର୍ଡର୍ସ ବି ଆପଣଙ୍କର ସେୟା ହେଇଯିବ କି ଆଟଲିଷ୍ଟ ବୁଧ ଗୁରୁ ଶୁକ୍ର 3 ଦିନ ହେଇଗଲା। ଆଫ୍ଟର ନୋଟିସ୍ ମ୍ୟାଟରରେ ଆପଣ ଯୋଉ ଡେଟ୍ ଯଦି ଚାହୁଁଛନ୍ତି ତାହେଲେ କୁହନ୍ତୁ ନହେଲେ ସେ ତାଙ୍କୁ ଛାଡ଼ି ଦିଅନ୍ତୁ ସେ କରିଦେବେ। ଆଫ୍ଟର ନୋଟିସ୍ କେ 22 22 ସो ଠିକ ଅଛି ଦିଅ 22 ଡେଟ୍ କର।
ମୋର କାମ ଅଛି
ଗୋଟେ
13/4
ଆଜ୍ଞା
13/7
ନାଇଁ ସେ ଚାହୁଁଛନ୍ତି ସର୍ଟ ଡେଟ୍ ଆପଣ ସର୍ଟ ଟୁ ଲଙ୍ଗ ଡେଟ୍ ବୁଝୁଛନ୍ତି 18/5 ତାଙ୍କର ଗୋଟେ ଡିଫିକଲ୍ଟି ଅଛି ସେ 4/5 ଆଉ ଯୋଉ 11/5 200 ଅଲରେଡି ରଖିସାରିଛନ୍ତି ପ୍ଲସ୍ କିଛିଟା ଆଡ୍ ହେଇଯାଇଛି ଯେହେତୁ ଫ୍ରାଇଡେ ହେଲାଣି ଆଡ୍ ହେଇ 200 ହେଇଗଲାଣି ଅଲରେଡି ସେ ୱିକ୍ ଗୁଡାକରେ
Item 20, my lord.
20 ତ ଆସିଯିବ
I day after tomorrow, my lord, because execution
ଆସିଯିବ
day after tomorrow.
ଆପଣ 20 ଆପଣଙ୍କର ଆଡଜଷ୍ଟ ହେଇଯିବ 29/30 ହେଇଯିବ
Because the date
ଆପଣ 29 ଚାହୁଁଛନ୍ତି
29.
ଆପଣଙ୍କ ପାୱାର ନାହିଁ ତ
Today I filed a press vocala, my lord.
20
So today I filed.
20ଟା 29 ତାରିଖ କରିଦିଅ
My name will be reflected.
Item ସେଟା ତ କିଛି ଅର୍ଡର ହିଁ ଡୋଣ୍ଟ
12 mine. Today I filed vocala, 12 mine.
12 ସାର୍ ଆସିଯିବ ଆଜ୍ଞା 30 ହେଇଗଲେ ହବନି ଆସୁ ଗୋଟେ ଦିନ ଆସିଯିବ ନା କେବେ କହୁଛି ପ୍ରୋସିଡିଂ କଣ ଇଣ୍ଟରିମ୍ ପିରିୟଡ ଥିବ ଆଇ ଅଣ୍ଡରଷ୍ଟାଣ୍ଡ ବଟ୍ ଆପଣ ତାକୁ ଫ୍ରିଡମ୍ ଦିଅନ୍ତୁ ସେ ତ କହୁଛନ୍ତି ଆଣିଦେବେ ସବୁଗୁଡାକ ଆସିଯିବ ସବୁ ଆସିଯିବ
Item 13, my lord.
13 ଆସିଯିବ
Can it be taken today, my lord?
ନା ନା ସେମିତି କହିଲେ ସମସ୍ତଙ୍କ
Pardon your lordship. Pardon your lordship.
ଆପଣଙ୍କର ଫ୍ରେଶ ଆଡମିସନ ଇଜ ବିଂ ଆଡଜଷ୍ଟେଡ ଯାହା ଅଲରେଡି ଆଡଜନ ଆଗରୁ ଅଛି ଏଗୁଡାକ ଆଡ ହେଇଯିବ ଗୋଟେ ଆଡ ହେଇଯିବ ଆପଣଙ୍କର 2 ତାରିଖ ଭିତରେ
अर्जेंट स्टे थिला सेथरे अर्जेंट 15 आइटम टारे
ନାଇଁ କୋଉ ଦିନ ନେକ୍ସଟ ଡେଟ୍ ଅଛି ଜାଣିଛନ୍ତି
नहीं चल पड़े नहीं तो रीट फाइल करछु
ସେଟା ତ କହୁଛନ୍ତି ସାର୍ ପ୍ରଭୁ କହୁଛନ୍ତି ପ୍ରଭୁକୁ ମନା କରାଯାଉଛି କଣ କରାଯିବ But Prabhu is being refused. There Prabhu is has vanished. Definitely asio. Up to orders of fresh admission is definitely distributed. Whatever may be the list, they have been added.
Item 22.
22 से जल्दी जाऊँ मेंशन करते
22 मिनट से अटैचमेंट ऑर्डर इशू कर दीजिए थोड़ा एग्जीक्यूशन में आई हैव चैलेंज द पीएलए अवार्ड so the it will be infructuous
केबे को आनिले हबो से तो बहुत ठीक सारीबा जल्दी
tomorrow
तो हबन घरे करिया
से अटैचमेंट ऑर्डर कर देलेनी परदिन कर दिन
से 18/5 रखथिले कोठे
मतलब
ताले आपण 22 टा को रखिबे 1/5 पानी रही
ठीक है
कोन 29/30 जो अछि ता भीतर एडजस्ट करा होछि 1/5 आपण देखिए को दिन कम होई परियो को दिन कम अछि फर एडमिशन ना जानना परियो
कम सारे से सदैश ऊपर एडजस्ट हो छै
सब गुडा का एडजस्ट हो जाय भीतर कम किछि नाही ता
कमेंसिंग 18
1/5 ठीक है
एक्चुअली फ्रेश एडमिशन मतलब नोटिस भी
आसु
मतलब
Item 35.
नहीं एक पेज तक शुरू है
Okay.
22 रु 25 आउ के मेंशन करछन
Pardon your lordship. Item 14, your lordship.
14
Hi, yes.
तो डेफिनेटली आसीबो
Petition copy.
डेट पर इंसिस्ट करंतु नि अप टू 21 ऑल मैटर्स हैव टू बी एडेड टू द लिस्ट ऑफ दिस वीक
My
Sure of
humble
that.
prayer is, your lordship, they have not submitted the petition copy till now. First,
तो नाहादी ताका absence से behind their back the same thing they will say that they did not inform me to make a mention before the court up to 21 are definitely listed
yes,
एक 22 रु 25 गला 22 है 1/5 then 26 रु 33 26 गोटे केबे करंतु
वी कमेंसिंग 29
ए शॉर्ट डेट से जल्दी एही विक्री करिवे स्पेशल बेंच को दिन अछि ठीक है ठीक है এই উইকରେ ଆଡଜଷ୍ଟ ହେଇପାରିବ 26ଟା 18/5 18/5 ମ୍ୟାଡାମ 27 ରୁ 33 34 ରୁ 39
item 35.
Hmm.
18 week commencing 18 हो
18/5
18
35
yes
ঠিক ଅଛି 36 ରୁ 39 ମିଷ୍ଟର ଶର୍ମା
ମୋଟା sir 13 ତ ଆପଣ କହିଲେ
sir definite it will be adjusted ଯାହା ବି ଥିବ ତା ଦେହରେ ଆଡ୍ ହେଇଯିବ
sir ये तो fresh admission ଟା ଆପଣ କହିଲେ ତ
ଆପଣଙ୍କର ଖାଲି dictation ଟା ମୁଁ ଖାଲି ଦେବାକୁ ରହିଲା ଏଇଟା dictation ହେଲା I come back because I have to attend some ସେ ଦିଟା dictation ଖାଲି ନେବେ ଆପଣ ଯଦି ରହିବେ most welcome after recess I have to dictate those orders ହେଲା ଆଉ ଗୋଟେ 16 ଆଉ କେତେଟା ରହିଲା ସେ dictation ପାଇଁ କେତେଟା ଦିଟା 10
Yes, sir.
Sadasya Mahapatra. No, sorry. Sadasya Mahapatra. You take your seat. I'll just take 2 minutes to complete the Sadasya Mahapatra for the stuff. Opposite party blank. The learned counsel for the petitioner is had at some length. She reiterates her submissions as noted in the earlier orders. The sum and substance of the submissions would be the petitioner is the wife of the deceased that resulted in unfortunate demise of the demise of her husband, Sri Apuranjan Mahapatra, who passed away in a motor vehicle accident on 5/9/2023 at about 5 a.m. at Barpani in the district of Bargarh. Within the police station, Barpali, corresponding to PS case number 297, case 9 to the registered as GR case number 284 of 2023. It is again reiterated by the learned counsel. Next point next point after the death of the husband of the petitioner, she is now having a strained relationship with her in-laws, and it is submitted that she has been driven out of her matrimonial home within court. She has been driven out within court, single court, matrimonial home, and stays at court. As already observed and reflected in order dated 24/2/2026. That it is not disputed. The accident took place under Barpali police station, the cause of action, all the evidences, witnesses, are within the territorial jurisdiction of the MSCT at Bargad. So therefore, the learned counsel for the petitioner is also apprised that by transferring to Puri, which is at about Bargad to Puri hobo, check kar devo. Bargad dash Puri is about 380 kilometers. Again, 399. It's almost there. 399 kilometers on the highway. It is apparent that before the MSCT, in the trial, seeking compensation, evidence needs to be adduced and the material is to be produced. In support of her summation, the learned counsel relies on section 166B.
166 clause 2.
166 clause 2 of the Motor Accident
MSCT Act.
The act, the said section is reproduced. In considered opinion of this court, since all the three are the claimants, that is the petitioner, her mother-in-law and father-in-law, before the MSCT, Bargad, the section cannot be selectively applied to exclude the choice of mother and father of the deceased. Exclude the choice of place of litigation. Exclude the choice of place of litigation of the father and mother of the deceased. Stop. It is further submitted by the learned counsel for the petitioner that the petitioner is apprehensive about her well-being and safety, and she cannot effectively appear at Bargad. In response to the said submission, the learned counsel was asked whether such facts have been brought to the notice of the learned MSCT, and if so, what is, if any, order has been passed by the learned MSCT. So, in response, upon instruction, is submitted by the learned counsel for the petitioner that she has no such instruction whether the MSCT was apprised of any such threat and difficulty in appearance. It is submitted by the learned counsel for the petitioner that the petitioner may be allowed to avail the ICT facilities. It is further observed that since you ICT paragraph if you apply, then the court will consider that remote deposition, remote appearance. With the aforesaid observation, the petition is disposed of. Copy of this order shall be forwarded to the so and so.
Highly obliged to Lordship.
Anything else, Mr. Mahapatra?
No, Your Lordship.
No submissions have been noted because I sought for your presence only because of that you should be satisfied that your submissions have been noted.
Yes.
So that is how I want to cross check. If I have missed anything, I'll just again reflect.
My only humble submission, if it is not possible to transfer the petition from the Bargad to Puri, then there is no.
A lawyer should not submit that because there is a rule.
Yes.
VC rules is there. It is
Yes,
not at the choice of the court or the High Court.
But
so if you apply and is something the court may accept or court may say whatever, but it has to follow the rule.
Yes, Your Lordship.
You read that Asian Resurfacing Allahabad Bar Association.
Yes,
the regulation of the lower court matters by the High Court, how the court has dealt with. It's a 5-judge constitution bench.
Yes.
They say that court should not interfere. And apparently it is not in your interest. And if the petitioner is apprehensive about getting the amount, you must assure as a lawyer that no one in the world can prevent her from getting her share.
Yes, but
Please appreciate that.
yes, yes,
There, your role is much bigger than the court.
yes.
Because court is not here to assure anyone, but a lawyer can tell. Suppose the apportionment is any problem, you challenge that.
Lordship, issue है कि वीडियो कॉन्फरेंसिंग रो accessible जिनसटा सब प्रकार डिस्ट्रिक्ट रे बर्तन फुल्ली अवेलेबल हेई जी बट सेटा समाने ड्यू टू इंटरनेट इशू सेटा समाने कवर अप
I am more aware of that.
yes
than
yes your lordship definitely
Because the facilities and all these things,
Yes.
so that is the order is structured if it is available.
yes हमें 3000
And
रुपए
Odisha is way ahead in India.
yes yes
Odisha, that much I can assure you.
yes
Every district headquarter is having,
yes
everywhere it is having. Now it is a little bit overburdened.
yes
गोटे दिन रे सकाळे जदि संबलपुर रे केस अछि से केस पडु पडु दीटा है
दीटा हेई जाउछ
Mr. Devata has told me, I remember, sir, I was present, but as the VC was not available.
yes
So it has now, I mean, even VC also has its limitations. There is
Yes.
some limitations have
Yes.
been found. But we are maintaining, and we are yet to stop it, we are encouraging also.
yes
And there is a rule.
hello blessed your lordship
Yes.
Item 16.
Is Tapaswini Sinha for the petitioner. Seta mention in it, like a regular matter. The matter being in the list is listed for orders. Matter being listed for the order in the list is mentioned by the learned counsel, Ms. Sinha for the petitioner. The learned counsel files memo of date enclosing a letter from the a message, enclosing a copy of the written WhatsApp message of the petitioner in her number, received in her number, copy of which is enclosed to the memo. What enclosed with the Pratham lecture? Enclosing a copy of the image of the WhatsApp message and how image of the image screenshot is image only. Most general term of image. The said letter from the said intimation from the said intimation in writing that has been received by the learned counsel for the petitioner in WhatsApp is reproduced here. हमारे एक जने की करछंती ओडिया टाइपिंग कर दोछु राजेश टाइपिंग रे कोन बेले बेले पिटिशनर निजे अपेयर करी ओडिया रे कोन ना copy of the memo is taken, memo with enclosure is taken on record, scanned copy be updated. The translation of the English translation करें देबे ना एटी करी बुझी देबे ट्रांसलेशन रे अल्प पांचटा सेंटेंस अछि पांचटा लाइन अछि ना अछि प्रेजेंट एड्रेस अछि उक्त केसटी को चलाइबा को चाहू नै एवं मते ता उठाइबा देबा को अनुमति प्रदान करा गले मु उपकृत हेबी एति की सब बाकी तो नेम एड्रेस और लाइक the translation is translation of the statement made by the petitioner in her message to her learned counsel is reproduced herein. Accordingly, the petition is disposed of. Copy of this order shall be forwarded. Still. Opening sentence the petitioner wife in the marriage had challenged the order. Challenges the judgment dated 18/5/2019 passed by the learned judge, Family Court, Jajpur. In criminal proceeding number 50 of 2018. Stop. The said judgment has been passed under section 127 into bracket 1 of the CRPC into bracket since repealed and substituted by perimeteria provision dash contained in BNSS 2023. The said 120, they said application under 127(1) CRPC was filed in the CRP number 145 of 2012, disposed of by a judgment dated 6/8/2014, directing payment of rupees 1,500 to the wife in the marriage and rupees 1,000 to the minor child born from the wedlock. What is the
No, no,
नहीं से मैच से एक्चुअली से बेच टा ओवर हे गला मेंशन करिया दरकार नहीं आपण जदी डेट चाहुचंती डेट टैक्स से कर देबे
এটা ଗୋଟେ ইন্টারমোডর ଥିଲା ই উইল ফাইল এ ট্রায়াল পিটিশন বিফোর দ লর্নেড জজ ফ্যামিলি কোর্ট
সেটা দেই দিও সেটা না সে নম্বরটা কো দেই দিও তো কো কেসটা
আইয়া
জাস্ট এটা স্কট কোন লিখছো The order of maintenance was enhanced by the learned judge family court to rupees 2,000 for petition number 1 and rupees 1,500 for the petition number 2 minor child. Stop. एतिकी तापरे ते लिखा है केते पर मैटर समझो
8
38 पोस्टिंग डेट कर दो तो ऑर्डर देखते इतने मॉडल डेट टा कोन तो सर
23/12/2025
एंट्री मॉडल हितला एठी
ସେଥିରେ ହେଇଥିଲା
कोऑर्डिनेट बेस ता मन
ଜଷ୍ଟିସ୍
नहीं डिसोरिएंटेड होतो जे जानना हंती मते कोन
नहीं,
चेक करी आपण
ଜଷ୍ଟିସ୍ ସଞ୍ଜୟ
साहब जस्टिस संजय मिश्र जहा जस्टिस एमएस सेया
ମେଲା
वकील भी से समान किंतु जणे वकील आपण मते जेते बडे कहउचंती यू शुड बी कॉन्फिडेंट ऑफ व्हाट यू आर सेइंग
माय लॉर्ड
so that my concepts I mean doesn't get confused.
माय लॉर्ड
आपण कहा पे सर
आई एम फॉर द पिटिशनर
the petition being in the list could not reach that WPC 36788 of 2025 item 38. The matter being in the list could not reach due to paucity of time is mentioned by the learned counsel for the petitioner. Upon on sir
GR Sahoo
per petitioner. The learned counsel for the opposite party is not available during the mention of the matter. Stop. The learned counsel for the petitioner refers to the interim order by the coordinate bench dated 23/12/2025. সেটা তো তারপরে কেবে কোন লিস্ট হইনি
তারপর লিস্ট ହେଇଥିଲା কিন্তু রিচ করলাନ୍ତି
তাহলে আজ তো রিচ করিনি
ନାଇଁ ସେଦିନ ମୁଁ ମେନସନ କରୁ ସାର୍ ଉଠିଗଲେ ଆପଣ ମୁଁ
আরে ଆପଣ ବୁଝି ପାରୁନାହାନ୍ତି ସାର୍
হ্যাঁ
ଆପଣ ସବୁବେଳେ ନିଜ ଇଣ୍ଟରେଷ୍ଟ ଜଗିବେ ନା ନାଇଁ ଅନ୍ୟ କଥା ଭାବିବେ ଯଦି ଆଗରୁ 23/12 ରେ ସେଟା ଅର୍ଡର ହେଇକି ଏପର୍ଯ୍ୟନ୍ତ ସଷ୍ଟେନ କରିଛି ଆଜି ଆପଣ ସେଟା କାହିଁକି ମେନସନ କରିକି ଗୋଟେ ଆଡଭାନ୍ସ ଅର୍ଡର କରୁଛନ୍ତି
ଟ୍ରାଏଲ କୋର୍ଟ ଶୁଣୁନି ଆଉ ଗୋଟେ ଅର୍ଡର ନ ଗଲେ ଟ୍ରାଏଲ କୋର୍ଟ
ଡେଟ୍ କେବେ ଅଛି କୁହନ୍ତୁ ତାହେଲେ ଆପଣ ସବୁବେଳେ ଚେଷ୍ଟା କରିବେ ପର୍ଟିକୁଲାର ସାର୍ପ ହେବେ ଆପଣ କୋଉ ଦିନକୁ ଅଛି ସେ ମ୍ୟାଟର ମୁଁ ଅର୍ଡର କଣ କରିବି ନା ବୁଝିପାରିଲେନି 23/12 ପରେ ଆର୍ଜନ ହେଇଥିଲା ଆଜି କେତେ ତାରିଖ
ଆଜି ହଉଛି 27
23/12 ପରେ 27/4 ଗୋଟେ ହାଇକୋର୍ଟ କଣ ବୁଝିପାରିବନି ଯେ ମ୍ୟାଟରଟା ଯେ ଆର୍ଜନ ହେଇକି ହେଇଥିଲା 23/12 ରେ ଆପଣ ଯଦି 23/12 ପୂର୍ବରୁ ମ୍ୟାଟରଟା ମେନସନ କରିଥାନ୍ତେ ଆଉ ଠିକ ହେଇଥାନ୍ତା 23/12 ପରେ ଯୋଉ ମ୍ୟାଟରଟା ଆପଣ ମେନସନ କରୁଛନ୍ତି ଦ୍ୟାଟ ଇଜ ନୋ ଅର୍ଡର ତେଣୁ ଆପଣ ଆଜି କହିବାକୁ ପଡିବ ଯେ ନେକ୍ସଟ ଡେଟ୍ ଅଫ ଲିଷ୍ଟିଂ ଇଜ ଅଙ୍କ ତାରିଖ କି ଗୋଟେ ମେମୋଟେ ଫାଇଲ କରିବେ
ନାଇଁ ଏଇଟା ଲିଷ୍ଟିଂ ଥିଲା ଲାଷ୍ଟ ଅର୍ଡର ହେଇଥିଲା 23/12 ରେ
आज्ञा कौन बुझुछ ट्रायल कोर्ट रे 23/12 पर जो मैटरटा जहाँ भी ହେଇଛି हाई कोर्ट रे केबे पोस्टिंग हेई नाही एंट्री ऑर्डर कंटिन्यू करूची आपनकर असुविधा होची जे ट्रायल कोर्ट इज प्रोसीडिंग तो सेटा हाई कोर्ट ऑर्डर रिफ्लेक्ट हेइनी केमती हबो आपण गोटे मेमो फाइल करिवे जे नेक्स्ट डेट ऑफ लिस्टिंग इज अमक so that I can direct the learned counsel for the petitioner states amko ki has filed memo the next date of listing is amko trial date is trial court is proceeding the matter may be adjourned
My lord.
कोन my lord कहले मो my lord लिखि परि से काहे से जिंस काहे कोन को जते बेले ट्रायल कोर्ट वकील की आपण निजे जे अपियर करछंती if you do not know the date how the court after that date of 23/12/2025 नेक्स्ट डेट थिला आपनकर 16 फेब्रुआरी 16 फेब्रुआरी परे जेबे भी ऑर्डर हाई कोर्ट करिवो either it is continuous or if it is not in continuity then it has to refer to the order of the trial court
नहीं एथरे ऑर्डर हेतला कि ट्रायल कोर्ट ता 16 फरवरी परकु पोस्टिंग
आपण जदि खाउछथि मु बुझी पारनी आपण मते बुझोछथि सेटा जमा करंतु मु देखु जे आई एम मच बेटर प्रिपेयर्ड देन यू इन योर मैटर 23/12 पर जो केबे हाई कोर्ट ऑर्डर नेक्स्ट डेट कहंतु आपण पचली ना केबे लिस्ट हेनी आ कहले जे आपण तरे मेंशन करथिले आपण उठी गले
यानी 16/2 रे लिस्ट हेतला 16/2 रे 2026 रे लिस्ट हेतला
सर ऑर्डर कोन हला
नहीं सेदिनो किछि रीच
सेटा तो मु आपण पचारछु सर 23/12 पर 16/2 रे कोर्ट कहले 16/2 रे किछि ऑर्डर हेनी ट्रायल कोर्ट जो प्रोसीड कले नेक्स्ट डेट को केबे को रखिले 16/2 पर जेटा आपण जानि ना
एग्जैक्ट डेटा जानि
exactly unexact date is a date sir
My lord.
unexact date किछि अछि कि डेट ही आपण जानि ना केबे आनि परिबे डेट
नेक्स्ट वीक
नेक्स्ट वीक रखि दियंतु एटा हला ताले आपण बदे कोन न जानि कहउछन जे ट्रायल कोर्ट इज प्रोसीडिंग इन द मैटर ताले
इंस्ट्रक्शन
डोंट गेस इट सर गेस कले प्रॉब्लम हबो ऑर्डर ही खराब हेजु माने जोडा का नॉन पर्टिकुलर नॉन स्पेसिफिक ऑर्डर्स that doesn't show well I mean that looks very I mean what you call it's very carelessness
sorry
को करया कथा नै सॉरी नो मो कथा मु कहूची मु आपण कथा कहू मु जदी नॉन पर्टिकुलर ऑर्डर पास करिवि ओके हबो that's my concept आपण के भाव पर्सनली नोचन दिसडा केबे रखिबे एटा
4-5
रखि दे आपण मेंशन करियो सर जेबे नेबे आसीबो आपण डेट जानिबे मेंशन करियो जदि ता आगुर लिस्टिंग चाहउछन्ती गोटे मेमोटे देबे कहिबे कोर्ट रे जे आगा एटा अछि हमको दिनो को ऑर्डर नाही इंटरिम ऑर्डर थिला से करिवे लिस्टिंग यस यस
Lordship, I am item 19, your lordship.
19 टा आसी all the matters up to 21 are coming adjusted within 1/5
Yes, yes.
correct
Yes, lordship. I'm much obliged to lordship.
all matters up to
Yes, miss.
yes miss Patnaik जदि डेट चाहउछन्ती से दे देबे आफ्टर नोटिस में टिके इंसिस्ट करंतु now he has crossed 270 in the 4 ଆଉ 11 18 रे already he has reached 270 तो सेटा भी आपण देखंतु मैडम यस
Lordship, the petition has become infructuous because
who item
17
17
again, as the cause of action is not
आपण
sufficient.
आपण कहा पे मैडम
Your Lordship, petitioner, Professor Dr. Sarat Chandra Swain.
Yeah, item 18, he has wrongly mentioned item 17. This is item 18.
17.
शरद
17.
17.
हाँ 17, sorry.
ଆପଣଙ୍କର 17 କହୁଛନ୍ତି ତ
Again, sir.
ସତ୍ୟନାରାୟଣ ମହାପାତ୍ର then ମିଷ୍ଟର ଉଦ୍ଗାତା ଇଜ ଦ ଅଦର ସାଇଡ
Yes, yes.
ଆପଣ ସତ୍ୟନାରାୟଣ ମହାପାତ୍ରଙ୍କ ପାଇଁ
On behalf of
ଆପଣଙ୍କ ନାଁଟା
Tanya Sarosh Naik.
ପ୍ଲିଜ ଲେଖି ଦିଅନ୍ତୁ ଫୁଲ ନେମ୍ Miss So-and-so on behalf of Satyanarayan Mahapatra for the petitioner, Mr. Satyabrata Udgata or Mr. Sanjeev Udgata.
Mr. Sanjeev.
Mr. Sanjeev Udgata along with Mr. Satyabrata Udgata for the opposite party. On 12/3/2026, the following order was passed. Today, the matter being in the list could not reach due to paucity of time. The learned counsel for the it after signature.
Sir,
ଆପଣଙ୍କ ନାଁଟା ତଳେ ଟିକେ ପଛରେ ନା ଲେଖିଦିଅ
against,
along with କରି ଲେଖିଦିଅ
against.
But the matter being in the list is mentioned by the learned counsel for the petitioner. She files memo of date, which states thus: the memo shall be taken on record, scanned copy be updated. In view of the above, the matter stands disposed of. Urgent certificate copy as well.
I am for opposite party number 1 to 3. Mr.
One second. मुझे देखिए.
Sorry, I am
Mr. Udgadale 1, 2, 3.
opposite party number 1 to 3.
17टा बुझी के आपण मिस्टर बारिक स्टेट काउंसिल के बुझी के कहिबे. 17 नंबर आइटम रे के स्टेट काउंसिल कहिले
प्रेम महांती सर your lordship प्रेम महांती
मत लागुची प्रेम कुमार महांती बट कहियो बल.
yes sir प्रेम sir
yes आपण कत बुझिले तो सेटा इतना आछो देले yes Mr. Padi any matter
21 on behalf of Mr. Nayak.
21 is listed.
Yes.
Please be sure that he's adjusting 20 all the matters by
Yes.